Please remain seated and come to order. Court is once again in session.
18 CF 839, Tina Jones.
People.
Jones.
Each with the models for people.
Morning, Your Honor. Good morning, Your Honor. Stephen Hall, H-A-L-L, on behalf of Ms. Jones, who is present and approaching the bench.
Comes on this morning for possible plea, correct?
Yes, Your Honor, we have resolved this pursuant to your agreement.
State what count are you proceeding on?
We're proceeding on count 7, Your Honor.
Other counts are being dismissed.
Upon a plea of guilty and finding of guilty to count 7, attempt first-degree murder, the people would be moving to nally press counts 1 through 6.
All right. And what is the proposed disposition?
On count 7, the defendant will be sentenced to 12 years in the Illinois Department of Corrections, to be followed by 3 years of mandatory supervised release. This defendant shall serve that sentence at 85% in accordance with the truth in sentencing provision of Illinois law. She'll receive 2 days credit for April 18th and April 19th of 2018. She was actually in custody. I know counsel had an opportunity to review the financial assessment schedules, and I believe he's going to be proceeding under the new schedule.
That is correct, Your Honor.
All right. Is there going to be statutory fines and costs?
No, Judge, there's a $1,000 fine, a $1,000 anti-crime contribution, and all other statutory fees and assessments mandated by law. There's also a restitution amount of $7,712, which will be paid to the victim, Kirsten Amport, directly from the defendant's bond. And I know counsel for the victim, Dave Amalski, is present in court, and he'd like to be heard on that.
Just may I approach?
Yes.
Your Honor, for the record, it's David Amelski, I-M-I-E-L-S-K-I. I represent Ms. Amport in this matter. That restitution amount is correct. She has asked me to ask the court to authorize that check be cut in her name, be released to me, and I will return it.
All right. That is going to come from the posted bond money?
Yes,
It
sir.
won't come from the bond, yes.
All right.
Thank you.
And DNA indexing?
DNA indexing pursuant to the statute with the $250 assessment.
Is there any other history?
No history, Judge.
All right. Ms. Jones, the charge here is a charge of attempt first-degree murder. It's brought as a Class X felony. It has a range of possible penalties of 6 to 30 years in the Illinois Department of Corrections. A sentence there is going to be followed by 3 years of mandatory supervised release or parole. It carries possible fines of up to $25,000. Those are the maximum penalties. Class X felonies are offenses for which probation is not available. That means if you were to be found guilty or plead guilty, you're subject to being sentenced to the penitentiary for some range between 6 to 30 years. Do you understand the charge and what the range of possible penalties are?
Yes, sir.
Did you hear the state's attorney go through the terms of this agreement?
Yes, sir.
Is that your understanding of what it is you are agreeing to? Before, it is my understanding that you wish to enter a plea of guilty to this charge. Is that
Yes, sir.
correct?
Yes, sir.
Before I accept your plea of guilty, I have to admonish you of certain things. As a consequence of a conviction or a plea of guilty, the sentence of any future conviction may be increased, or there may be a higher possibility of the imposition of consecutive sentences. As a consequence of a conviction or plea of guilty, there may be registration requirements that restrict where you may work, live, or be present. As a consequence of a conviction or plea of guilty, there may be imposed on your ability to, among other things, retain or obtain housing in the public or private market, retain or obtain employment, retain or obtain a firearm, an occupational license, or a driver's license. Do you understand that?
Yes, Your Honor.
Knowing those things, ma'am, do you wish to continue with this plea of guilty?
Yes, Your Honor.
Do you understand you had the right to have continued with your plea of not guilty and to have asked that your case proceed to a trial?
Yes, Your Honor.
You were entitled to have a trial in front of a jury where we would have selected 12 jurors to hear the evidence. They would have decided whether you're guilty or not guilty. Or you could have waived your right to a jury, asked for a judge to hear the case, and the judge would have decided whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand that if you're going to be pleading guilty today, you're giving up your right to such a trial?
Yes, Your Honor.
You're also giving up your right to have required the state to bring in witnesses, try to prove this charge. Witnesses that you and your attorney could confront and cross-examine. You're giving up your right to have subpoenaed witnesses on your own behalf. You're giving up your right, if you would wish, to present evidence or defenses in your own behalf. You're giving up your right to either testify or remain silent. and you're giving up your right to have required the state to have been able to prove you guilty by proof beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
Again, ma'am, knowing what your rights are, do you wish to proceed with this plea of guilty?
Yes, Your Honor.
Are you entering this plea of guilty today freely and voluntarily?
Yes, Your Honor.
Has anyone in any way forced you or coerced you to doing this? Other than the agreement we've talked about, has anyone made any other promise or representation to you in order to get you to plead guilty?
No, Your Honor.
Are you presently taking any type of medication or drug, or is there any other factor that would in any way affect your ability to understand what is taking place here today?
No, Your Honor.
And you understand what has happened. You just entered a plea of guilty. What's left to be done is to impose this agreed-upon sentence.
Yes, Your Honor.
And you understand this sentence is being served at 85% of the sentence that is being imposed. You understand that? And just so the record is clear, 85% of a 12-year sentence is 10 years, 2 months, and 12 days. Do you understand that? Are you satisfied with the representation of your attorney?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
State the factual basis.
Thank you, Your Honor. At trial, the evidence would show that in April of 2018, Naperville and Woodridge Police received information from a producer of the investigative TV series 48 Hours that they had uncovered a murder plot targeting a DuPage County resident named Kirsten Amport, A-M-P-O-R-T. A subsequent investigation revealed that the defendant, Tina Jones, the person standing two to my left, had contacted the website called Sicilian Hitman International Network to hire a hitman to kill the wife of a man that she worked with. The defendant accessed the website by using a special dark web browser designed to conceal her IP address and her identity. A search of the defendant's laptop revealed that she had had several electronic communications with the website's administrator. In those communications, the defendant conveyed personal information relating to Ms. Amport and her husband, Jeffrey Amport. Electronic communications relating to hiring a hitman to murder Ms. Amport were also found. Those included conversations relating to the cost of hiring the hitman. The defendant provided information about the victim to the website, including the victim's address, her husband's work schedule with instructions not to harm the husband, and she also sent the administrator a photograph of the victim. In order to hire the hitman, the defendant made several installment payments to the website's administrator using Bitcoin, which is a form of cryptocurrency, in an effort to conceal her identity. Over the course of approximately 3 months, the defendant made approximately $12,000 worth of Bitcoin payments. Further investigation revealed that the website was a fraud. It purported to host a marketplace for hitmen and their would-be solicitors. However, the site was a scam and provided no such services to its clients. The defendant was developed as a suspect after it was discovered that she worked with the victim's husband and may have been motivated. The defendant was interviewed, and she admitted that she had accessed the Hitman website and paid the Bitcoin in an attempt to murder Kirsten Amport because she wanted a relationship with Jeffrey.
To me, the state has witnesses who have called to testify, would testify substantially in that manner.
We agree that would be the testimony at trial.
The court finds a factual basis for the plea, finds it was entered voluntarily. Defendant understands the nature of the proceeding. The court accepts the plea, enters the finding of guilty, accepts the agreement, sentences the defendant to 12 years in the Illinois Department of Corrections, to be followed by 3 years of mandatory supervised release. The sentence to be served at 85% of the sentence imposed. Credit for 2 days actually already served. DNA indexing in the assessment, the $1,000 anti-crime commission contribution, the $1,000 fine, DNA indexing, and the assessment, any other mandatory statutory fines or cost, and restitution, and the amount of $7,712. Is that it?
That's correct, Your Honor.
All right.
Yes.
Ms. Jones, you do have a right to appeal. If you wanted to appeal, you have to file a written motion with the court within 30 days of today's date. Ask the court to withdraw your plea of guilty and vacate the judgment. In that motion, you must put forth the reason or basis you would ask the court to do that. Otherwise, it might be waived for appeal purposes. If you cannot afford it, a copy of a transcript of this proceeding would be provided to you at no cost. An attorney would be provided to help you prepare that motion. If I granted your motion, your case would be reset down for trial, but the state could then reinstate all of its original charges. If I denied your motion, you'd have 30 days from that date to file your notice of appeal. Again, if you could not afford it, an attorney would be appointed to represent you on appeal, and transcripts would be provided to you at no cost. Any questions?
No questions, Your Honor. One additional matter. When Ms. Jones was arrested, there was some evidence that was taken into custody, a laptop and some other personal effects. We're asking that that evidence, since it no longer has value to the state, be returned to Ms. Jones' family. We're agreeing that the laptop can be wiped if necessary of any remaining evidence that's on the computer.
State, any objection?
We don't have any objection, and I think the discussion also was if in the future there was ever a need to present that evidence at any future hearing or court proceeding, that the defendant would waive any foundational objection.
That is
Correct.
accurate.
All right. That being the case, we'll go with my deputy, ma'am, please.
Thank you, Your Honor.
Thank you.
We want to take a break, I think. We're going to take a short recess.